Hi, this is Manji Singh from Law School 101 and this is a video in the Legal Aptitude series brought to you by Law School 101 for CLAT aspirants. In this video, we will be covering law of contracts. We know that besides offer, acceptance, lawful consideration, and lawful object, that capacity to contract and free consent are also essential requirements to constitute a valid contract. In this video, we will be focusing on capacity to contract and free consent. Hence, this video will discuss minors, unsound mind, persons disqualified by law, coercion, undue influence, misrepresentation, fraud, and mistake. This will be followed by previous year questions related to the same topic. Questions from CLAT 2017, ILAT 2017, CLAT 2016, and ILAT 2016 will be covered. Alright, let's begin. Capacity to contract. The law restrains certain individuals from being a party to contract primarily for the reason that they are deemed unfit of fulfilling the responsibilities of a contract. Section 11 of the Indian Contract Act lists the qualifications of a person who wishes to participate in a contract. The section reads, every person is competent to contract who is of age of majority according to the law to which he is subject and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Therefore, minors, individuals with unsound mind, and persons disqualified by law are not allowed to be a party in a contract. Let's cover these individually. The first category is minors. Individuals below the age of 18 or whatever the age of majority is for the law concerning the object of the contract cannot hold any contractual obligation to any person. This is regardless of whether the other party knew of the minority of the individual or not. Further, any transactions made in favor of the minor cannot be recovered because the law treats the contract as if it never happened. Hence, if a money lender lends money to a minor, the amount becomes irrecoverable. However, the Contracts Act does not provide for no contractual obligation towards the minor. Hence, if a minor has paid some amount in return for a service as part of a contract, upon the minor paying the sum, the other party becomes legally obligated to perform the service and the minority does not take away from the contractual obligation of the service provider. Contractual obligations to minors must be performed. The next category is individuals of unsound mind. For a contract to be valid, it is required that the parties both be of sound mind while entering the contract. This means for a person of unsound mind, intervals of sound mind can be periods in which he or she can enter into a contract. Similarly, a normally sound mind person cannot enter into contracts when in unsound state of mind. The burden remains on the person in this case to prove that he or she was of unsound mind at the time of entering the contract. Now let's move on to our third category, persons disqualified by law. Certain individuals become disqualified by law and are prohibited from entering a contract. For example, a convict. Now we move on to free consent. Both parties should be free to consent to or decline to a contract and should enter the contract voluntarily. The condition of free consent is not met when one or more of the following is present. They are coercion, undue influence, misrepresentation, fraud, or mistake. Consent that has been obtained by coercion, undue influence, misrepresentation, or fraud is voidable. It can be enforced at the option of the party whose consent has so been obtained. Consent that has been made by mistake is void. It cannot be enforced by either party. Let us discuss this further. Coercion. Section 15 of the Indian Contracts Act defines coercion as committing or threatening to commit any act forbidden by the Indian Penal Code of 1860 or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever with the intention of causing any other person to enter into an agreement. It means threatening to do something illegal or take an illegal action to the party or to the party's interest, like his family or property, in order to obtain their consent to the contract. It is immaterial whether the Indian Penal Code is or is not enforced in the place where the coercion is employed. For example, A, on board of an English ship on the high seas, causes B to enter into an agreement by an act amounting to criminal intimidation under the IPC. A afterwards sues B for breach of contract at Calcutta. A has employed coercion, although his act is not an offence by the law of England, and although Section 506 of the IPC was not enforced at the time or place when the act was done. Now we move on to undue influence. Many relationships exist in which one party is often superior or in a place to control the free consent of the other party. When there is a contract between two such parties, undue influence needs to be considered. Section 16 of the Indian Contracts Act gives a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Further, a person is deemed to be in a position to dominate the will of the other when he holds a real or apparent authority over the other, or where he stands in a fiduciary relation to another, or where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental and bodily distress. Hence, keep a lookout for these three types of relationships. 1. With real or apparent authority. 2. A fiduciary relationship, which is a relationship based on trust. And 3. A person whose mental faculties are affected. When the transaction appears on the face of it or on the evidence adduced to be unconscionable, the burden of proving that such contract was not induced by undue influence shall be upon the person in a position to dominate the will of the other. Let us discuss some situations. Number 1. A, having advanced money to B, his son, during his minority, upon B's coming of age, obtains by misuse of parental influence a bond from B for a greater amount than the sum due in respect of the advance. A employs undue influence. The next situation is A, a man enfeebled by disease or age, is induced by B's influence over him as his medical attendant to agree to pay B an unreasonable sum for his professional services. B employs undue influence. The next situation is A, being in debt to B, the moneylender of his village, contracts a fresh loan on terms which appear to be unconscionable. It lies on B to prove that the contract was not induced by undue influence. And the last situation is A applies to a banker for a loan at the time when stringency in the money market. The banker declines to make the loan except at an unusually high rate of interest. A accepts the loan on these terms. This is a transaction in the ordinary course of business and the contract is not influenced by undue influence. The next category is misrepresentation. Misrepresentation means and includes 1. The positive assertion in a manner not warranted by the information of the person making it of that which is not true though he believes it to be true, or 2. Any breach of duty which, without an intent to deceive, gains an advantage of the person committing it or anyone claiming under him by misleading another to his prejudice or to the prejudice of anyone claiming under him. And number 3, causing, however innocently, a party to an agreement to make a mistake as to the substance of one thing which is the subject of the agreement. This means that misrepresentation means making the other party believe something to be true without the intention to deceive, which is not true or that the person believed to be true. Now we move on to the next category, that is fraud. Fraud means and includes any of the following acts committed by a party to contract or with his connivance or by his agent with intent to deceive another party thereto or his agent or to induce him to enter into a contract. Number 1. The suggestion as a fact of that which is not true by one who does not believe it to be true. Number 2. The active concealment of a fact by one having knowledge or belief of the fact. Number 3. A promise made without any intention of performing it. Or 4. Any other act fitted to deceive. Number 5, any such act or omission as the law specifically declares to be fraudulent. Mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. Let us discuss some situations. A sells by auction to B a horse which A knows to be unsound. A says nothing to B about the horse's unsoundness. This is not fraud in A. Situation B. B is A's daughter and has just come of age. Here the relation between the parties would make it A's duty to tell B if the horse is unsound. Situation C. B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing. Here, A's silence is equivalent to speech. Situation D. A and B, being traders, enter upon a contract. A has private information of a change in prices which would affect B's willingness to proceed with the contract. A is not bound to inform him. Now we move on to mistake. Agreements are void where both parties are under mistake as to matter of fact. Where both the parties to an agreement are under mistake as to the matter of fact essential to the agreement is void. An erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not deemed to be a mistake as to matter of fact. Let's look at some situations. Situation 1. A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party was aware of these facts. The agreement is void. Situation 2. A agrees to buy from B a certain horse. It turns out that the horse was dead at the time of the bargain, though neither party was aware of the fact. The agreement is void. Situation 3. A, being entitled to the estate for the life of B, agrees to sell it to C. B was dead at the time of the agreement, but both parties were ignorant of the fact. The agreement is void. Now let's cover some previous year questions. We shall begin with CLAT 2017 questions. Do pay attention to the explanation of the questions. The first question is principle. It is a case of fraud where a party to a contract knows or believes a fact to be true but conceals it actively from the other party with a view to induce that person to enter into a contract. Facts. While taking a life insurance policy, in reply to questions by the insurance company during the inquiry into his proposal, Zamir deliberately concealed the fact of his medical treatment for a serious ailment which he had undergone only a few weeks ago. The answer options are: Number 1, the act of Zamir did not amount to fraud as disclosing the fact would have resulted in exposure of his privacy. Number 2, the act of Zamir amounted to innocent misrepresentation. Number 3, the act of Zamir did not amount to any misrepresentation. And number 4, the concealment of the fact by Zamir amounted to fraud. The correct answer choice is option 4. You can eliminate option 2 and option 3 to begin with because misrepresentation has not been discussed in the principle. This is a pretty straightforward question. We know that the insurance policy is a contract and that the question almost exactly tells you of the active concealment on the part of Zamir, and the principle tells you that the active concealment is fraud. Hence, the act done by Zamir has amounted to fraud. Now we move on to the next question. Principle. If a party to a contract agrees to it under undue influence of another party, then the party under the undue influence may refuse to perform in accordance with the agreement. Facts. A rich youngster, became a member of a religious group and soon he was appointed by P, the head of the group, as his personal secretary. As per the rules of the group, all officials and staff of the group were supposed to stay in the group's official premises itself. Some days later, A was asked by P to execute a gift deed in favor of P, in which it was mentioned that all his immovable properties in his name are being gifted to P. A was unwilling to execute the deed, but he was forcefully restrained by P and his bodyguards in P's office made A sign the gift deed. Soon after this, A left the group and refused to hand over the property as agreed in the gift deed. Is A's action valid? Your answer options are: number 1, A executed the deed under compulsion and undue influence and was right in withdrawing from the contract. Number 2, it is illegal for religious groups to acquire property from its members. Number 3, as the gift deed was executed by A, he cannot refuse. And number 4, as gift is also a contract, the consent of A was not obtained by P while executing the deed. The correct answer choice is option 1. In this question also, it is very clearly mentioned that A was otherwise unwilling to execute the deed and that he was forcibly restrained by P. This amounts to coercion as well as undue influence, but sticking to the principle only, we know that A is not obliged to honor the contract as his consent was unduly influenced. The next question is principle. Where one of the parties to a contract was in a position to dominate the decision of the other party, the contract is enforceable only at the option of the party who is in a position to dominate the decision of the other party. A doctor asked his patient to make a payment of 10 lakh rupees for treatment of his fever. The patient paid an amount of 5 lakh rupees and promised to pay the remaining amount after the treatment. After the treatment, the patient recovered from the fever. The doctor demanded the remaining amount from the patient. The patient refused to pay. Before we continue, the principle reads, the contract is enforceable only at the option of the party who was in a position to be dominated by the other party. Now the answer options. Number 1, the contract is not enforceable without the consent of the patient. Number 2, the contract is not enforceable as doctor was in a dominating position. Number 3, the contract is enforceable against the doctor. And number 4, the contract is enforceable against the patient by the doctor. The correct answer choice is option 4. In this question, the patient had the option of refusing to consent to the treatment, in which case the doctor would have been unable to dominate the patient. Therefore, the contract is valid and the consent has been freely given. Hence, the contract is enforceable by the doctor. There were no questions in the IELTS 2017 paper related to this topic specifically. So now we move on to the CLAT 2016 questions. Question. Principle. Mere silence as to facts likely to affect the decision of a person to enter into a contract is not fraud. Facts. A sells to B, A's daughter who is a minor, a horse which A knows to be unsound. A says nothing to B about the unsoundness of the horse. Now, the answer options are: number 1, B can take the plea of fraud because she is a minor. Number 2, there cannot be a contract between a father and a daughter. Number 3, A has not committed fraud. And number 4, A has committed fraud. The correct answer choice is option 3. The situations that we discussed earlier were taken right out of the Indian Contract Act of 1872. However, you are not required to apply any of that extra knowledge here. So, following the principle only, the principle states that it is mere silence does not amount to fraud. Accordingly, in the question, A has kept silent, which does not amount to fraud. Don't apply any additional information. Even if you believe the principle is wrong, only apply it nonetheless. The next question is principle. A person who is usually of unsound mind but occasionally normal may take a contract when he is not of unsound mind. Facts. A generally remains in the state of unsound mind and barely or rarely becomes capable of understanding things. The answer choices are: number 1, A can make a contract when normal. Number 2, A can make a contract only for his own benefit. Number 3, A can never make a contract. And number 4, A can make a contract at any time whenever he pleases. The correct choice is option 1. This has been discussed to some length earlier in the video. We know that individuals who aren't mentally unsound we know individuals who aren't mentally sound cannot enter into contracts, but during the periods of mental soundness, they may do so, which is also what the given principle says. When A is capable of understanding things, in those times he can enter into a contract. There were no questions in the ILET 2016 paper related to this topic specifically. So, thank you for watching this video. For more resources, follow, like and share our page Law School 101 on Facebook. Subscribe to our main YouTube channel by the same name. Also, we encourage you to post your doubts, queries, questions in the comment section below. Best of luck, law aspirants.